My name is MacKenzie. I am Director of AML and Economic Crime Risk at Amiqus. Amiqus is a full suite AML onboarding platform. We pride ourselves on being trusted, fast and accurate. We are indeed trusted by 9 out of 10 of the largest law firms in Scotland. We perform ID and V checks, electronic ID and V checks, risk assessment, source of funds, source of wealth, screening, adverse media, PEP and sanctions screening, and moreover an end-to-end record-keeping solution for law firms. With me today I've got Kayleigh Smale of Smale Compliance. I've been dying to work with you for a couple of years now. I see your stuff on LinkedIn. We've met a couple of times. We're both really passionate AML geeks, right? We've got the I Love AML mug in front of us. So I'm really chuffed you could make it today. So thank you.
Thank you so much, Graham. So hi, my name's Kayleigh. And I am the Director of Smale Compliance, and as Graham said, I'm a real AML geek, love everything about it, and I do consultancy, going into law firms and helping them with their AML compliance.
Source of funds, look, you know, if I was to say one thing about source of funds, I think it is, and source of wealth, but moreover source of funds, it is the most important AML check you can do. Why do I say that? Well, it's at the very heart of good AML control. If there's one thing you do really well in your CDD, your EDD, it's checking the provenance of the source of funds involved in a client or a transaction. You can verify the identity of Kayleigh Smale or Graham MacKenzie 10 times over. But is it actually really going to get you closer to whether or not that individual is a money launderer? Probably not. Nine times out of 10, you're not going to get to that truth. But understanding the source of funds involved in the transaction is going to get you closer to that truth. ID and V, verification of identity, is really important for a variety of reasons, not least to report suspicious activity to the authorities with verified information, or for doing sanctions, adverse media, PEP screening, but actually understanding the provenance of the funds involved in the deal is critical. Kayleigh, have you any thoughts on that?
Yeah, it's a real hot topic at the moment, isn't it? The SRA have said that they're going to be doing their thematic review on source of funds and source of wealth. There's a lot of pressure on law firms at the moment with the Solicitors Regulation Authority. They're knuckling down. We're seeing those fines coming out all the time. And, you know, firms are really struggling with source of funds and source of wealth. You the same, doing consultancy, audits, those sorts of things. Source of funds is something that firms really do struggle with. So I think it's really important that these sorts of conversations happen. It was quite funny the other week. I was chatting to someone not in the regulated sector, and they said they were asking my mum and dad for 10 years worth of bank statements. I was like, give them my number. But it's just, knowing where to stop as well.
Okay, yeah, and I should also say it's not just the SRA. I headed up AML at the Law Society of Scotland, which is the AML supervisor for the Scottish solicitor profession. So I was doing a lot of inspections with my team up in Scotland. And of course, source of funds, source of wealth is a hot topic across the UK. Solicitors in Scotland still struggle with it as well. I was heavily involved in the creation of the LSAG guidance, the most recent revised version of the LSAG guidance. And, you know, undoubtedly practitioners will have seen there's a lot more information on source of funds, source of wealth in the LSAG guidance for that very reason. Probably a good idea just to go over very briefly the definitions of source of funds, yeah? So the money laundering regulations only mentions source of funds 3 times under under ongoing monitoring, under PEP relationships and HRTCs, high-risk third countries. Source of wealth only mentions it a couple of times. Anyway, then you have to look at the LSAG guidance, and the LSAG guidance adds colour to the regulations and adds definitions in there. But effectively what the LSAG guidance says is it's not just about it's coming from a UK bank account or the remitting details, but it's looking towards you to understand the origins of those source of funds. Yeah, not just the remitting details, but an understanding of how those source of funds were accumulated in the first place. Kayleigh.
Yes, I really like that you brought up the whole UK bank account. Like, you know, you don't have to just focus on that. Actually, a lot of misconception, I call it the UK bank account myth, where everyone thinks that money coming from a UK bank account is actually okay. It's not. We had the case of NatWest, who were fined quite a lot of money. And in that case, we had people going in with black bags full of cash. In one place, they took in £700,000. That poor cashier that had to count all of that money. But they should have had baddies written on their forehead, shouldn't they? So it just goes to show that actually money in a UK bank account doesn't mean that it's okay. So you need to understand, yes, the money's in the bank account, but we need to understand how they've come to get that money.
Absolutely. And just to mention source of wealth as well. It's important to this. So, source of wealth really comes into play in high-risk situations and EDD situations, and that's really to assess the origin of the client's entire body of assets. So, I guess the economic, the business, the commercial activities that then generated that overall body of wealth associated with the client, and any main drivers any accumulation of wealth over time. So that's the difference. Source of funds is really talking about the specific funds involved in a transaction, whereas source of wealth more to do with EDD situations, enhanced due diligence situations, and it's the overall body of wealth that client holds.
And it's just important to note that this is where the risk assessment comes in as well. So in terms of source of funds, you need to be doing it on a matter-by-matter basis, whereas a source of wealth, it's unlikely to change very often. I mean, you still probably want to have that understanding and make sure that you understand it. But when it comes to source of funds, it needs to be done on a case-by-case basis, because it's whatever that particular transaction, whatever money they're using for that particular transaction.
Yeah, absolutely. I think it's important that no one's suggesting that lawyers are turning forensic accountants here. They don't need to go into the weeds of an individual source of wealth, but they do need that overall understanding of the main drivers of that source of wealth.
I have seen quite a lot that in conveyancing it is something that they really struggle with. So in terms of, you know, they need to understand where the funds are coming from for whatever transaction that's going to take place. And it can be pretty much anything, as we all know. So it can be really tricky. And, you know, I think people are stuck in this 6-month bank statement thing. I know, like, you have to have a starting position, and 6 months bank statements is a great starting position, but actually you need to be understanding, one, do they have enough money for the transaction to take place, which is important, but more importantly, where are those funds coming from, and how did they gain those funds?
Yeah, no, I mean, I agree with that. And you know, certainly in conveyancing, it's about 6 months, 12 months bank statements. So we'll go on to bank statements in a wee while, but you know, they can be useful, but it's not about just taking those bank statements. Oh, that's me done with source of funds. You need to understand those bank statements. What are the bank statements telling you? You know, do you need to account for every nickel and dime of an individual source of funds? No, but you need to understand that that individual could have saved that amount of money over a set period of time. Obviously, bank statements won't show you every source of funds. I mean, you'll be in situations where, you know, a client has come into inheritance or has drawn down an annuity from, say, Standard Life or whatever. Well,
I've noticed, like, premium bonds are really big at the moment. When I was doing my file reviews, premium bonds, a lot of people are using premium bonds at the moment. So making sure that you've got the evidence for that. But okay, we see the premium bonds, but where did the money come from that?
You may have a situation where you've got a client or clients who are, say, retired teachers downsizing and buying a bungalow, and you can see evidence that they have been teachers, whether that be through a pension statement or elsewhere. Well, then, you know, that transaction probably makes sense. Yeah, it's not as complex as a multi-layered transaction. Where there are more red flags and risk factors, where you would need to collect more evidence to substantiate the client's source of funds.
Yeah, and that's like the 10 years worth of bank statements that I found from someone. Again, it was a very vanilla matter, same sort of situation. They were downsizing and they were asking for 10 years worth of bank statements. It's just absolutely crazy. It's really important to look at the risks of the matter as well, and that's when they kind of do start to collide.
Yeah, absolutely. So if we very briefly talk about trust and company service provision as well. So if you're setting up a company on behalf of a client, you're providing a registered office, you are being a company secretary, etc. Well, source of funds is still relevant in those situations. So i.e., even where monies might not be flowing through your client account, yeah? And that's, if you look at LSAG guidance 2B, now you might not know this, but there is a LSAG guidance 2B. There is also a 2A and a 2C, but let's concentrate on 2B. Well, that talks about, under the client due diligence and risk assessment section, for those types of matters, TCSP activity, those types should include, where applicable, details of how the entity or arrangement is or has been funded. I.e., if you're setting up a company or you're acting as a registered office, you need to at least obtain a picture and risk-based evidence of how an entity or an arrangement has been or will be funded. So I think that's really important, and I'm not sure that all practitioners really understand that either.
I'm not sure that it's happening in practice, to be honest. Yeah. When I'm doing audits and speaking to people, then actually sometimes they just don't, it's just not included in whatever they're telling me when they're starting to do their matter. So that's really important, because again, where are those funds coming from? How are they starting this stuff? It's the same with the transfer of shares as well. All of those sorts of things where actual physical money isn't moving, but actually there's a lot of money laundering that could go on.
Yeah, and that's exactly it. So if you look in terms of POCA, Proceeds of Crime Act, section 327, 328. 327, a person commits an offence if he or she conceals, disguises, converts or transfers criminal property. Really wide ranging, right? 328, a person commits an offence if they enter into an arrangement. Yeah. Now, if you think about it, TCSP activity could easily be an arrangement, so that is very much in scope. And looking down the barrel of one of those offences, and I'm doing work in the TCSP space, I really want to have an understanding of where the money flowing through a company I've set up is coming from, and I think that's really critical. I think it's really important to understand all of this, source of funds, source of wealth, for TCSP conveyancing, all in scope activity. But I think that really needs to be put into the context of the wider client profile. So this notion of holistic due diligence. So is the source of funds involved in a transaction or a client what you might expect, given the wider background and context you know about that client, yeah? Whether or not that client has made a lot of money selling a company a few years ago, or a company that you're working on behalf of is selling widgets to the EU. Well, does the source of funds involved in those sort of transactions make sense?
Well, that's it. I was just about to say that. Does it make sense? And that's the most important thing when you're looking at source of funds and the source of wealth, when you're trying to decide whether or not it is okay. Does it make sense that they have this source of funds based on the activity that they're doing, in terms of what their job is, in terms of what, their company is? It's really, really important to understand that. And it is that feeling, isn't it? And I think the problem with lawyers, they love everything. I love these chairs, because it's really important. They're it's not black and white. It's really tough for them. They like to be told. But when it comes to source of funds, you can't give them an answer for everything without seeing the particular case and the matter, what's in front of you.
Absolutely, and that is a great segue into a risk-based approach. Yeah, so
I love a risk-based approach, those lawyers.
So I mean, in the context of client due diligence, let's talk about risk-based approach.
I know that law firms find this really tricky because, again, they like that black and white. They like to be told exactly what they need to do. And this is when policies and procedures are really important, because the risk-based approach will be dependent on that individual law firm and the risk that they have. It takes you all the way back to your firm-wide risk assessment in terms of what your policies and procedures are going to be, in terms of what your risk-based approach is. You'll have some firms that do lots of high-risk work. So in terms of that, they might do a lot of enhanced due diligence. I mean, they might not call it that, but actually, you know, the fee earners are being made to do a level that's higher than they might necessarily need to do, but that's where the law firm has decided that their risk-based approach sits.
Based on their PWRA, right?
Exactly, based on that. And it's really important, and that's why a firm-wide risk assessment, as well, or practice-wide risk assessment, is really important for firms as well. You kind of need that first before you can lead it into your policies and procedures, because that defines how risky you are as a firm in terms of, right, for these departments we need to be doing X, Y and Z. And like I said, it can be completely different for different law firms. You know, I've seen lots of different approaches depending on what type of work that they do.
Yeah, absolutely. But I think fundamentally it's about identifying and evaluating and assessing risks in the context of your practice, of your client and the matter that you're dealing with, and then implementing the right level and, importantly, the right type of due diligence to mitigate the risks you're seeing. And that includes, of course, the right type of source of funds and source of wealth checks as well. So, yeah, understanding the risks inherent in the client or the matter, and then implementing the right controls to mitigate those risks. That ultimately, that's what a risk-based approach is, right? And obviously the level and types of risks dictates then the level and types of due diligence that you perform. And obviously in higher risk situations, that would then mean enhanced due diligence, probably including certainly in conveyancing, more emphasis on source of wealth checks as well. Yeah. Okay, but I think it's really important to emphasize the type of due diligence involved. So there's no point in, if you have identified through your risk assessment that source of funds, for example, is of higher risk in this matter, there's not really much point in doing extra verification checks on Kayleigh Smale.
Oh, yeah. I see that quite a lot.
Yeah, what's the point?
I see it quite a lot, yeah. and firms do that. They think, oh, it's high risk, so now we need to actually get more ID, like another proof of address. What's that going to do? How is that mitigating the risks? No, actually here we need to be doing more on the source of funds and understanding that a bit better and gathering evidence surrounding that.
Yeah, ask for the type of due diligence, whether that be verification or source of funds, source of wealth, whatever it is, to get you comfortable with the risks involved in that client or that transaction. And therein lies the link between risk assessment and source of funds and source of wealth. Fundamentally, the higher the inherent risk involved in a client or a transaction and the risk factors present, as assessed through your risk assessment, the more extensive and detailed those source of funds and source of wealth checks should be, and the more evidence you should be collating and analysing.
Think of crypto.
Yeah.
Cryptocurrency. I mean, I don't like it. I'd rather stay away. I will find an expert to help you with that. But, you know, if you've got cryptocurrency, it's classified as high risk. In England and Wales, the SRA have said this is high risk. I think it's the same it'll be the same in Scotland as well. So you need to be you need to make sure you have a better understanding and you're getting enough evidence to make sure that you feel comfortable about where the funds are coming from. And a lot of the time I see a lot of firms getting an expert in when it comes to those sorts of things.
Oh yeah, absolutely. I mean, ultimately as an ex-supervisor, where I see a solicitor, a firm, undertaking that risk assessment, a thorough and detailed risk assessment, and then marrying up the results and findings of that risk assessment with the due diligence performed, and using that due diligence to really mitigate those risks, record keeping, ensuring you've got a good record of what you've done and why. That is the key to good supervisory outcomes as well, whether that be the Law Society of Scotland or indeed the SRA or LSNI, whoever.
I think as well, it also helps law firms evidence their ongoing monitoring. Yeah. So like the risk assessment is really, really good place for them to be able to do that, especially if they're doing it through different points throughout the matter. You know, some people have like triggers to say to them, right, we've got all of our evidence at the start, that's fine. Right, let's do another trigger when we get source of funds. And they're writing about source of funds and then they're checking it all again at the end. That's also helping them with their ongoing monitoring.
Yeah,
Just wanted to throw that one in there.
No, absolutely. It's really, and certainly Amiqus, within the Amiqus platform, we have risk assessments built in with sections where you can, for ongoing monitoring purposes, look at the risk at the start of the relationship, or the conveyancing, for example, in the middle and at the end, just before any funds actually move as well.
And that's it. That's what the regulator's looking for. When they say they don't want a tick box exercise for a risk assessment, they're not saying you can't have tick boxes, because obviously some of them are, is it a PEP, yes or no? Like there's nothing more you can really do with that question. But actually afterwards saying it's a PEP and these are the things that we've put in place to mitigate those risks, that's the gold dust.
Yeah, absolutely. And like, is it a PEP, yes or no? Well, yeah, what risks does that PEP pose? And this is the due diligence we've put in place to mitigate those risks. Yeah, exactly. I think it really, again, just to emphasise, no one's asking you to turn Sherlock Holmes here. Yeah, but ultimately you do need to have and collate enough information to make you comfortable with regards to the due diligence and taking on, obviously, the client and ultimately taking on the client.
So that leads us on really nicely to the sorts of evidence
yes.
that law firms need to be getting. Yeah. And obviously both of us, you having worked as a regulator, me doing my audits, we've seen a range of things,
we have
we?
The good, the bad and the ugly. It's safe to say, let's be honest. But yeah.
I mean, if that's on the file at all.
yeah, exactly. You know, but okay, yeah, let's talk about that. Will I talk maybe a bit about bank statements first?
Yeah, let's do the bank statements.
Okay, let's do bank statements.
Law firms love a bank statement.
Yeah. So, like we talked about this very, very briefly earlier, but bank statements, it's not just about getting a bank statement and putting it on file. It's not just about taking 6 months, 12 months, 18 months worth of bank statements. It's about what those bank statements actually say. Does it marry up with your understanding of the client and the nature of their business, their occupation, etc.? Does it make sense that, say, someone's saved up for a deposit on a house, that they could have saved up for that deposit given, say, the salary that you've seen coming in and savings to a savings account, whatever it might be? How far back do you go? 6 months, 12 months? To be fair, it's about what you see in those, yeah? If it takes 18 months, well, you might go back 18 months, but I doubt it, because you can really get quickly a summary of general account activity in a lot shorter period of time than that. And how far back really depends on what you're looking for in those bank statements, right?
Yeah, exactly. I find you have sometimes like 3 types of lawyers. You have the one that will try the forensic and say there was £15 that went into your account and it was by someone that we don't know. You know, it was, you get those sorts of lawyers. Then you have the ones that, you know, do what they need to do. They have that understanding, right? So he's earned his salary is £5,000. That means it was okay for him to save £1,000 a month into his account because he's living with his mum and dad. It's all about that story behind, isn't it? And a lot of criminals don't have that story, that backstory to be able to, you know, make you feel comfortable that actually what they're saying is true. And obviously then they don't have the evidence to back it up either. So it's those sorts of things that they need to be looking at. And like you said, it's not necessarily about getting 18 months worth of bank statements. That's not necessarily going to help. And the source of funds could be anything. It could be they've sold a car. Okay, prove it. You know, I had once before, he'd apparently sold light fittings on Facebook Marketplace. Okay. It was an interesting one. We're like, okay, where are the messages from Facebook Marketplace? Because obviously it's really difficult to be able. It's like a £15,000. It was a lot going towards the deposit. No, don't have any. Okay, right, now I'm starting to get suspicious. Maybe I just wanted a bit of evidence to begin with. Now I'm getting a bit suspicious. And then it was, okay, well, what did you pay for the light fittings in the first place? We got a receipt for £3,000. Now they've obviously really ripped someone off here, or there's something not quite right going on. And it's those sorts of questions that you need to be thinking about when you see something that you don't feel comfortable about.
And that activity flowing through the bank statements, because that's why and what you're looking at the bank statements for, right?
Exactly.
And do the activity on the bank statements, does it look, general? So then does it look what might be termed normal? So, my bank statements, I'm sure yours does as well. You might get a salary in or drawings from your business in, and then there will be money going out on a mortgage, a mobile phone bill, insurance.
Oh God, mine's Just Eat.
Yeah, Just Eat. Tesco, whatever it might be, but that's the sort of activity, right, that you normally see. And but I've seen statements taken on by solicitors to prove source of funds, where all you're seeing in is regular round amount cash credits in, and then similar amounts straight back out again. That's not really normal activity, and that's the sort of activity that you absolutely should be questioning. I mean, I think you may have concerns at that stage. You might then go back out and ask for further information, like in your example. But then either those concerns are allayed, you can get on with the transaction because you've got more evidence to back up what the client's saying, or those concerns are elevated into suspicion, at which point, obviously, you need to report that to the NCA under the SAR regime.
Yeah, and I will say that actually there are some really good law firms that do pick this sort of stuff up. I've been before in a meeting, it was something completely separate what I was there for, and the MLRA was having a discussion with one of the fee earners and basically said, they work for the NHS, they're saying they're frugal, they don't spend a lot of money, but they don't even have electricity bills coming out. Do they say that, are they living in squalor? And straight away they said, no, we're not taking it on then, we don't want to deal with this. So there are people out there that are really looking at this and really reviewing it.
Yeah, absolutely, and it's heartening to see that. And I think it's becoming, hopefully through videos and webinars and things that content creation like this, along with a lot of great work the Law Society of Scotland are doing, the SRA are doing, that's getting these messages out there. So I think that we are seeing an uptick on good quality source of funds, source of wealth checks in the industry.
Yeah, definitely.
Yeah.
It's still a tricky one though.
It is, and it's really difficult, especially when you're balancing all those checks with running a legal practice and trying to serve and fulfill the needs of clients as well. I think that's, again, where technology can help. Amiqus does provide, open banking technology. You can get bank statements through. That can really help you. It's not a panacea, and no system is a panacea for this sort of stuff. You've still got to analyse those bank statements, but it can make your job a lot easier. And Amiqus is doing a lot of work actually at the moment with regards to enhancing our source of funds, source of wealth checks as well. So that's coming down the line as well. So reasonable steps. What do we mean by reasonable steps in day-to-day legal work, Kayleigh, in terms of source of funds? You go first.
Reasonable steps.
Yeah.
So I think we've covered that quite a lot actually in terms of does it make sense? Yeah. So it's just making sure that they've got sufficient evidence to feel comfortable. So when it comes to reasonable steps, it will depend a lot on the matter.
For me, reasonable steps is absolutely depends on the client, the matter in hand. And reasonable steps for one transaction will be different to another, absolutely. But I think across the piece, there's a couple of things I would note. Take an attitude of professional skepticism. That's not to say that you think that all your clients are money launderers, they're patently not. But trust them, but then verify what they've got to say.
Yeah, I think that's where, for me, being in the money laundering sector, I actually could conjure up anything in my head. Yeah, I could see something, and I've done it before. I've gone to law firms and I've gone, right, there is so much information here. That file's crossing over with that file. How do these two people know each other? There's money coming in everywhere. I'm like, there is something dodgy going on. And then I sit down with the fee earner and I speak to them and they're like, oh, well, yeah, but he got his money because of this and he does this and that. And this is why they're connected. And I'm like, oh, please just write it down. Because if it was written down, then I would have had that understanding and it would have made things a lot easier. It's all of that stuff that goes on in the background. And sometimes they have clients that they've known for a very long time. I don't know that. Yeah. The regulator doesn't know that. Yeah. So it's really important that those sorts of things are written down.
Yeah, absolutely. And ultimately, would you be comfortable in a period of time, maybe years' time, being able to explain your actions and the due diligence you've collected either to your partners, to law enforcement, God forbid, or your supervisor in disciplinary action? Ultimately, that is why record keeping across all this stuff is so vitally important.
So I think when it comes to source of funds, one of the most important parts of it for me is the does it make sense? It's really important. Does it make sense that this person has that job and they have this amount of money and they get paid this amount of money, and then were they able to save that sort of money? And that's where you don't want just 6 months bank statements. You actually want to make sure that you've got enough evidence to show you all of those different things. A lot of law firms, what they have on their forms that go out to client, what's your occupation? It's so important, and I don't think people actually look at that as part of their AML, because understanding their occupation will really help you with that. Does it make sense to me?
It's all about holistic due diligence. What do I mean by that? It's about understanding the context and the background to your client. Kayleigh's just made given a good example on occupation for private clients in a business. Well, does the business make sense? Are they trading? Can you see stuff in company's house that shows that they're trading? Do you see invoices? Is it invoices for what they've told you they do for a living as a company, etc.? And is it the type of turnover you might expect for that type of business? All those sort of things is what I would deem context and background and holistic due diligence. And that is what fundamentally, that should be then put in context of source of funds and source of wealth, and indeed all the other checks. Does the source of funds involved in the transaction, source of wealth and the overall client marry up to that context and background?
Yeah. Also, does the transaction make sense for that type of client? So it's a terrible example, but I always use this example about how we've got a hairdresser and all of a sudden she's buying a dog meat factory. Like, that does not make sense, So it's like, does the transaction make sense? And then obviously do the funds then that flow from that. Also with that, you've got a hairdresser who's high street hairdresser doing well for herself, but how is she able to purchase £1 million warehouse? So it's all of those sorts of things as well.
On record keeping as well, something I would say is ultimately, do you remember algebra at school? Yeah. So algebra at school, you may not come to the right conclusion, but you will get marks for your working if you can show to your regulator, to law enforcement, to your partnership, whatever, that it made sense what you'd done. Yeah, in the context and of the client and the transaction. You may not come to the right conclusion. It's very difficult to spot a money launderer quite often, yeah. But if you've done all the reasonable steps, yeah, that will certainly help you too.
Yeah, that's really, really important. And it's like, give yourself credit for the work that you're doing. Don't need it in your head, we need it down on that paper, because I know no lawyer, or not any lawyers, would actually not do what they need to do. So they've got it all in their heads, like, yeah, I know this client, and I know we get that whole, I've known this client for ages and it really irritates us, but actually I've known them, I've been dealing with his transactions, I've been, working with him on his money, I know everything about them and I'm comfortable with that. Just make sure that that's written down. So, in 10 years time, if it does come to bite you on the bum, you can say, well, I did everything that I need to do, like you just said. That's
all part of context and background as well. Yeah. No one's saying that, it actually says in the outside guidance under the long-standing client section that you can use that information in your risk-based approach. Yeah, but you still obviously have to do what you need to do under the money laundering regulations and outside guidance. Yeah,
I think what a lot of people don't realise is actually they are completing the risk assessment. in their heads. So, I mean, it does, like, they are actually doing it. They're going through the motions. They're trying to understand the client. They're trying to understand the funds. And it doesn't need to be that, like, I've ticked all these boxes off. Actually, in your head, you've already done this. Yeah. Just make sure that it's down on paper, because you don't even need to call it a risk assessment. You just need to write it down.
Yeah, if it's not written down, it didn't happen.
Exactly.
Yeah. Amiqus and Aventine Labs and Smale Compliance, we're working together to provide this content on source of funds, source of wealth, and the risk-based approach, because it's so vitally important, and it's something, as we said at the start, the practitioners continue to struggle with. So this is the first in a series. We're going to be doing a white paper, which will outline some of these topics as well. And then we're also going to be doing a webinar. Kayleigh, I know how excited you are about a webinar. So am I. Not quite as excited as you, but excited nonetheless.
Well, I do love AML.
Yes, and I do love AML as well. So that's going to be coming soon. So hopefully you can join us for that too. So thank you very much.